Welcome to this explainer. You know, if you've ever felt totally overwhelmed by dense legal jargon or government gazettes, you are absolutely in the right place. Today, we're taking the South African Mental Health Care Act of 2002 and translating it into a clear, empowering guide just for you. Let's dive right in and break down exactly how this legislation protects and empowers citizens within the mental health care system.
The official South African coat of arms establishes the absolute authority of this act. This isn't just a set of friendly guidelines, it's a legally binding framework built by the state. And its primary mission? To protect vulnerable populations and make sure care is administered fairly and safely across the board.
To keep things simple, we've broken this explainer down into four main parts. First, the purpose of the act, then your mental health rights, next, the review boards, and finally, pathways to receiving care.
Okay, let's jump into Section 1, Purpose of the Act, the philosophy of protection.
Right off the bat, the preamble of the Act states that the Constitution prohibits unfair discrimination against people with mental or other disabilities. I absolutely love this, because before the document even touches on hospitals or treatments, it roots itself firmly in human empathy. It acknowledges that health is about physical, mental, and social well-being, and it demands that an individual's dignity is always front and center.
So what's the actual goal here? Well, the state is fundamentally obligated to provide community-based care and actively promote your mental well-being. The primary objective is to regulate mental health care, ensure everyone has equitable access, and integrate these services into the general health environment. We're way past the days of simply locking people away in isolation. It's all about providing the best possible care efficiently, and always in the user's best interest.
Moving on to Section 2, your mental health rights, shielding the vulnerable.
Chapter 3 of this act guarantees some seriously sweeping protections. We're talking absolute respect for human dignity and privacy. It explicitly protects users from exploitation, abuse, and forced labor, meaning care can literally never be used as a punishment. Plus, your health records are kept strictly confidential. And if you need to submit applications or appeals, you have the absolute right to a legal representative. Even if you can't afford one, the state provides legal aid to ensure you're never left fighting the system on your own.
Now, this part is fascinating. Consent to care is generally the absolute rule, right? But the Act does carve out some very specific, extreme emergency situations where care can be provided without it. This is strictly limited to scenarios where delaying care could result in death, irreversible harm to the user, serious harm to others, or severe property damage. It's a really delicate balance between respecting someone's bodily autonomy and stepping in to prevent an immediate tragedy.
That brings us to Section 3, the review boards, systemic safeguards.
Because let's face it, rights are only as good as the systems that enforce them. So who's watching the health facilities? Enter the mental health review boards. Think of them as the official referees of the system. By law, each board has to have between 3 and 5 members, and they absolutely must include 3 specific experts: a mental health practitioner, a legal professional like a magistrate, and a member of the community. This exact combo ensures a perfectly balanced, unbiased oversight body that really understands the medical, legal, and community context of every single case.
And these boards wield incredible power as independent watchdogs. They directly handle appeals against decisions made by hospital heads, they make binding decisions on assisted or involuntary care, and they review those critical 72-hour assessments. They even oversee transferring users to maximum security facilities. Basically, they're the ultimate double check on medical professionals, making sure the immense power of the mental health system is kept totally in check.
For our final section, Section 4, Pathways to Receiving Care, Practical Steps.
Let's map out how to actually navigate this system in everyday reality. It is crucial to understand the dividing line between types of care. Voluntary care is straightforward. The user submits willingly and gives informed consent. But assisted care? That kicks in when a user needs interventions but is incapable of making informed decisions because of their mental health status. And shifting from voluntary to assisted care triggers a very strict sequence of legal procedures.
The Act has a very specific definition for an assisted mental health care user. It's someone incapable of making informed decisions due to their mental health, but, and this is the key phrase here, who does not refuse the health interventions. So if a loved one lacks the capacity to consent but isn't actively fighting help, they fall right into this category, which unlocks a specialized, heavily monitored pathway for their care.
Chapter 5 of the Act outlines the exact legal mechanism for securing help for an assisted user. You can't just have anyone make this application, and a single doctor can't just make the call in a vacuum. It is a highly rigorous process.
Here's exactly how the steps break down. Step 1, a written application has to be submitted.
usually by a spouse, next of kin, partner, or parent. Step 2 is super critical. The head of the facility must have the user examined by 2 separate mental health care practitioners. This independent double-check is there to completely eliminate the risk of systemic abuse. Step 3, the head of the establishment approves or denies the application based on those 2 practitioners' findings. And finally, Step 4, the applicant gets a written notice of the decision.
And the oversight doesn't just stop once someone is admitted. The system keeps ticking automatically. Within just 7 days of approving assisted care, the facility head has to send a copy of that application straight to the review board. Within 30 days, that independent review board investigates the user's capacity and care circumstances. Then, 6 months later, there's a mandatory review to see if the patient has recovered their capacity. This entire timeline is literally hardwired into the law so that nobody simply slips through the cracks.
I want to leave you with this final empowering thought. This act isn't just a list of rules for doctors. It's a shield and a toolkit for citizens. Armed with this clear understanding of your fundamental rights, the oversight of the review boards, and the legal pathways to care, you're no longer in the dark. So, now that the legalese has been decoded, how will you use this framework to demand the dignity, respect, and proper care that every citizen truly deserves? Thank you so much for joining me for this explainer, and definitely keep this knowledge close at hand.